Well, good evening, everyone, and thank you for joining. I'm Michael Ettinger from Ettinger Law Firm, and this is our webinar, Four Advantages of Using Trusts. I'm very glad you could join me tonight. I enjoy giving these talks. I've been giving them for 35 years, since 1991. And I think you'll find it very helpful in moving your knowledge forward about trust, which seems to be very mysterious, but really a lot of it is common sense. Unfortunately, today a lot of people get their information on the internet, and I write a column, some of you may know, in 13 newspapers for the last few years across New York State. And recently I wrote a column entitled, "In Elder Law and Estate Planning, There's More Misinformation than Information." So tonight I will give you information that you could use that's specific to the state of New York, which is what you need to know. So let's get started. There's a picture of our staff. I'm in the middle at the top. To my left, as you're looking at the screen, is my lovely wife and law partner, Suzanne, and a number of our other lawyers and support staff are here. As you can see, we have the 35th anniversary banner because the firm was founded in 1991. I had already been a lawyer for 11 years. I was admitted to the bar in 1980. So it's getting to be a lengthy career, but I enjoy it every day. So I thank you for joining me with this seminar tonight. Ettinger Law Firm, our practice is limited to elder law estate planning, and that consists of trusts and estates, wills and probate, estate tax saving strategies, and Medicaid trusts and Medicaid applications. We have two offices in Nassau County. We're in Rockville Center, Lake Success. In Suffolk, we have three offices. We're in Huntington, where I am tonight. Suzanne and I live here in the town of Huntington in the Centerport area. And we have one in Islandia. So Melville, Huntington, and Islandia in Suffolk. Staten Island, we're at 900 South Avenue. Westchester, 140 Grand Street in White Plains. Rockland County, we're in New City. Orange County, we're at Crystal Run by the State Police Barracks. Dutchess County, two offices, Fishkill and Rhinebeck, and in Albany, we're right there on Wolf Road, where we've been for more than 30 years. So when we talk about elder law estate planning, it's fair to ask, what is it? What is elder law estate planning? Well, it's an area of law that combines the features of elder law, which is disability planning, and estate planning, which is death planning. And we use trust to create order out of chaos. And to give you an overview, I'm going to tell you how trusts avoid the pitfalls of wills. But before I do, a number of you sent in questions in advance, which I'm going to answer at the end of the presentation. But also you can type in your questions as we speak, and I'll also answer those live at the end of the talk. I hope you'll be able to stay and listen to other people's questions and what the answers to them are. So trusts save time and money in settling the estate because they don't have to go to court to settle. We'll get into that, of course. They avoid legal guardianship if you become disabled. That's a process where a court appoints somebody to handle your affairs for you because you don't have a plan and you're unable to handle your affairs for yourself. We want to keep our assets in the bloodline instead of going to in-laws. The trend today is to set up bloodline trusts. So you'll learn about this. They go to your children, sons and daughters, but if they die, instead of it going to their spouses and outside your family, it goes to their children by blood. If they don't have children, it goes back to their brothers and sisters. It keeps your assets flowing in the bloodline. And finally, we want to protect our home and life savings from the extraordinarily high costs of long-term care, whether it's home care or facility care. And overall, we want to keep control in your family and out of the court system. Control is a very big issue. For me as a lawyer, I like to see my clients have control and keep control. And you'll see through the presentation that nothing we're going to do here involves a loss of control. Even irrevocable trusts, you can have complete control of if you know all the rules and you know how to do that, which we're going to learn tonight. But elder law estate planning is really all about control. If I had to describe it in one word, the word would be control. We want to control who handles our affairs if we become disabled. We want to control who gets what, when they get it, how they get it, et cetera, et cetera. So there's the overview. Let's go into some detail here. Trusts protect you from guardianship proceedings if you become disabled. Wills don't. Well, guardianship is a bit mysterious. Probably everybody knows that Britney Spears was in a guardianship. Casey Kasem was in a guardianship. Guardianship is what happens for people who haven't planned. So one of the issues with wills, and one of the reasons wills have fallen into disfavor, is because a will takes effect on death. So obviously, there's no plan there for disability. And because of advances in medical science and people living so much longer, today about half of all people become disabled before they die. So if you only have a will, you don't have a plan for what happens if you become sick, homebound, disabled, lose cognitive ability. And if you don't have a plan, we'll see what happens. But the reason trusts have become popular is because it handles all three phases of your life. Today, while you're healthy and competent, you can run it. You can say who takes over if you become disabled, unable to handle your legal and financial affairs. And the test for that is getting a doctor's note saying that you're unable to handle your legal and financial affairs. And a trust says who gets the assets after you're gone, just like a will, but without the court proceeding. So we know about half of all people will have a period in their lifetime where they can't handle their affairs. And if you don't have a plan, New York State has written a plan for you. It's called guardianship. Now, you may have appointed somebody your power of attorney, which is quite a useful document to have. It allows somebody that you choose, or more than one person, to handle your legal and financial affairs if you become disabled. But even though you have a power of attorney, it doesn't stop a guardianship. The judge in New York can cancel your power of attorney and pick somebody else as a guardian to handle your affairs. Why would they do that? Well, it turns out that when people enter into a nursing home, very often the nursing home wants to be in charge because you're in their care and custody, really, and they want to have control of your affairs to make sure they get paid. And judges seem to be very sympathetic to these types of arrangements because the nursing home has no control over what the power of attorney will do and whether the assets will be used for the person that's living in the nursing facility. So they'll apply to the court. They say, we would like to be in charge. We're taking care of the person. We have these tremendous expenses. And the judge can cancel the power of attorney and pick somebody that the nursing home favors. We don't want that to happen. So once a guardianship is started, and this could happen outside a nursing home, it happens to people very often who don't have a spouse. They're widowed, widower, they never married, and they're alone. And a neighbor, a friend, a relative, lawyer, a doctor, somebody makes a report to the local Department of Social Services that something's amiss with you. You're not handling your affairs properly. You're not exercising proper hygiene. And even Department of Social Services can start a guardianship to make sure that somebody's looking after your affairs. So the court chooses who the legal guardian will be, and this often is a stranger to you. The problem is, once you get in, it's almost impossible to get out. The key is to prevent yourself from getting in, because to get out of a guardianship, you need a court order, and you have to go back to the same court that created the guardianship. So not going to have much luck with that. These proceedings are expensive because they involve multiple court hearings. They take time, and they're stressful. They're stressful because you don't know who's going to be in charge, and you don't know how much it's going to cost. One of the issues that we want to avoid in guardianship is the protection of assets. So let's say you have a few $100,000, whatever it is, and a legal guardian is appointed. Now you need care or you need to go into nursing facility. Well, the legal guardian, being that they're your legal guardian, can only spend the money on you. The law allows you to protect assets by gifting some of them to your children. In fact, you can always save at least half the assets, even on the nursing home doorstep. It's an advanced elder law technique. It's called half a loaf planning. You know the expression, half a loaf is what? Better than none, right? So I can save half by giving it to the kids. It's a little more complicated than that, but that's the net effect of it. But if you have a legal guardian, do you think the legal guardian could take half your money, give it to your children to protect it from long-term care? Well, of course not, because the legal guardian can only spend the money on you. So you can prevail on the legal guardian. Oh, please make an application to the court to protect some of mom's assets. Well, I've been there, and I did manage to convince a legal guardian to make the application to the court to protect some of mom's assets who was in a nursing home. And lo and behold, the judge turned down the application because the judge said, well, in my opinion, it's mom's money. It should be used for her care. And if there's anything left, it goes to the children. Why did that happen? Because it was the judge's values that prevailed because the judge was in charge. The family would have wanted to protect what they could, but they didn't have the power to do it. Conflicts will arise between what the family wants and what the guardian wants. And of course, the guardian has all the power. So what are we talking about here? We're talking about the gremlin that I started with is loss of control. We don't want this to happen. We want to have control over our lives and our assets. We certainly don't want to go to court and have a judge pick somebody to handle things for us. So the way we avoid that is by setting up a revocable living trust. And we'll see how that works. But it's one of the big reasons why people set up trusts, because they want to have their own plan for disability, not New York State's plan. So unlike a will, a trust takes effect while you're living. Well, that's why it's called a living trust. You see that. And it stays in effect when you're disabled. So let's say your name is Mary Jones. You set up the Mary Jones Living Trust, and you appoint yourself trustee or manager of the trust. So you're Mary Jones, trustee of the Mary Jones Living Trust, dated, whatever the date of the trust is. Now, for a trust to work, you have to put your assets into the trust. If you have a deed to your home, we'll prepare a new deed and deed the house from you, Mary Jones, or if you're married, Mary and Bill Jones, to Mary Jones, trustee of the Mary Jones Living Trust, or Mary and Bill Jones, trustees of the Jones Family Living Trust. If there are two trustees, it's like a joint account. Either of them can act, and then we'll change the name of your investments, your bank accounts, everything in the name of the trust. The trust uses your social security number, one of the spouses first. If that spouse dies, the other spouse. There's no tax return for the trust. In fact, it's exactly the same as you, except the name is a little bit different. Nothing actually happens effectively, legally, or financially unless and until somebody dies or becomes disabled. Until that time, you run things the same way as you did before. You file the same income tax return as before. It's really a plan for death or disability. So you name the backup trustee. If you're single, you're going to name a person. You can name two people. You can name three people. Any of them can act. You could name one person first, and if they're unable to act, the second person, and then the third. It's very flexible. If you're a couple, well, you're both trustees. So it'll be if the second one dies or becomes disabled, then the backup trustee takes over. Again, disability, have to produce a doctor's note. Your treating physician says you're unable to handle your legal and financial affairs. So you name your backup trustee. Well, this is an element of control, isn't it? Because if you name the backup trustee, that's the person you chose, not who the state chose. If you joined this late, you can post your questions. I can't answer them during the talk, but if you type them in, I'll be happy to answer them at the end, and I hope you can stay and listen to those. But now the person or persons are in control instead of the legal guardian. So I like to say, you're only as good as your backup plan, and this is your backup plan. with a guardianship in a court, it's impossible to get back control. But if it's your own people, it's easy. You take back control whenever you're ready. Um, but remember, I said a few moments ago that the court can cancel your power of attorney. Well, fortunately for all of us here this evening, the court cannot cancel your trust. The trust is stronger, overrides the court proceeding, which means you're guaranteed to get the people you choose in the event of disability. Well, this is going to make all the difference in the world, because what are those people going to do? Well, they're going to call Ettinger Law Firm, like people do many times a day, every day, and say, you set up a plan for so and so 20 years ago, or 30 years ago, or 18 years ago. Now so and so is no longer able to handle our affairs. What do we do now? And of course, we're very compassionate in situations like that. We've been there. Myself, I've been there with family members, but I've been exposed to thousands of people, and it's a very hard thing to deal with. So, first off, we're very caring about it, understanding about it. It's painful, it's stressful, it's overwhelming. So you have to deal with it in a very effective and stress-reducing way. In fact, I keep on my desk in each of my offices a stone, and if you can see it, oh, there it is. It says, "No worries." And the reason I keep that there facing the clients is because I believe one of the most important things you can do as a lawyer is reduce or eliminate anxiety and stress in a client. So that's one of our primary goals and considerations, to relieve your stress, calm you down, reassure you, give you the safety and security you're looking for. So now the person calls us and we'll say, well, you're in charge under the terms of the trust. These are your options, A, B, C, D. This is what I would recommend. And like to think about it, we'll talk about it in a few days or whatever the circumstances are. Sometimes we have to wait till rehabilitation finishes, determine what the facility says in terms of discharge of the individual. Do they need nursing home care? Can they go back home? How many hours do they need? What is the complete situation there? So the main thing here is the family is going to be able to go to their lawyer, get their advice, and they'll be able to act instantly to put that into effect. I mean, it's the opposite of a guardianship, where you're often involved in months of court proceedings with a disabled person. Here, we're talking about really getting the answers right away and being able to take steps right away. It's just a world of difference. So if you're dealing with a stressful situation like that, you want to have a trust where it can act immediately, because also in terms of asset protection, the sooner you act, the more that you can protect and save. Let's take a moment and talk about powers of attorney. They're not all created equal. We use something we call the elder law power of attorney, and it's stronger than the standard form. It's prescription straight. So the standard form of power of attorney that lawyers use in New York is actually what I call over-the-counter medicine. This is prescription strength. And I use that analogy because it works just like medicine. What happens if you have over-the-counter medicine, but you need prescription strength? We know what happens. It's not strong enough. It doesn't work. Same thing with power of attorney. The standard form power of attorney that's in the statute book that most lawyers use doesn't allow us to do most of the things we need to do if someone becomes disabled. And the number one thing is being able to transfer and protect assets in the event of disability. So imagine this. The standard form power of attorney allows your agent to gift out of your name every year $5,000. Well, if you have $500,000, and I can only give away $5,000 a year, and you have to go into nursing home, what's going to happen? In 3 years, you'll have zero, and your family will end up with $15,000 because that's all we could gift. Under the law, if you have $500,000 and you're going to nursing home tomorrow, I could save $250,000 by giving it to your children. It's an advanced elder law technique. It's called half a loaf planning. But if you have 500,000, I could gift 250,000 to your children. As long as I spend the other 250,000 on your care, the family gets to keep the gift. Of course, if I could plan 5 years ahead of time, I could protect the whole 500,000. But here we're talking about we didn't have any chance to plan. Mom or dad has to go into a nursing home for whatever reason. There was no planning done, and now there's 500,000. If we have the elder law power of attorney, I can move that 250,000 because the elder law power of attorney has an unlimited gifting power, not limited to the 5,000 a year, no limit. So if we need to move 250,000 to save it, we can move it. If we need to move 500,000, we can move that. If we need to move 1,000,000, we can move it. Can always save half. Of course, you want to be careful who you give it to, but most people have somebody who they trust and who they can make this power of attorney available to in the event they become disabled. So we like trust, avoid guardianship, keep control in the family. You have all your asset protection options, and we want that prescription strength elder law power of attorney. So if we do need to move assets, we can move whatever the law allows us to save, the unlimited gifting power. So number one reason, trust avoid guardianship. Number two, trust protect you from probate court proceedings on death. Wills don't do that. So one of the drawbacks in wills is the will, which is witnessed and supervised by a lawyer to witnesses, etc. It actually has no effect and no validity unless the court has determined it's a valid will. How does that happen? That is a so-called probate proceeding. Probate actually comes out of the Latin word meaning to prove the will. The will has to be proved to be valid. So even though you've named the executor, it's witnessed, etc., you still have to submit it to court to prove at the time of signing that will, you were of sound mind, memory, and understanding. You were not under any fraud or undue influence. You were able to read and write and converse in the English language. So we have to prepare a petition alleging all of these legal conclusions, submit it to the court, and now we have to wait for the court to rule. How long will that take? Depends what county you're in. In the Bronx, it could take quite a few years. In Queens, it can take time. In Brooklyn, it takes time, years. It's faster in Nassau and Suffolk County, Westchester County. When you get outside the city, it's faster. But this is if there's no controversy. If there's controversy, forget it. I can't find a witness. There's a challenge, all kinds of issues. A proof problem. There's no affidavit of witnesses. Unlimited number of issues. In fact, I would like you to know the reason I'm sitting here today and talking to you about this is because I was a litigation attorney for 11 years. From 1980 to 91, I was a litigation attorney. Late in 1990, I was in my car at the time on the Taconic State Parkway, and I was going to visit a person who had a personal injury. So I was going to see them. And I heard on the radio that there was a seminar coming up on trust, and that if you set up a trust, you don't have to go to court to settle. So I picked up my mobile phone, which those days was an actual telephone in the car. It had a receiver, just like the one you had at home. And I called, and I said, I'd like to go to this seminar. And they said, fine. And I went to the seminar. And sure enough, this was the very, very beginning of the Living Trust Revolution. It just started. It was given by an insurance person, actually. In any event, I thought this was terrific, but I didn't believe it. I had to look into it. And in fact, I went down to Florida and I got trained with some of the best estate planning lawyers in the country at the time. They were in Florida. You can probably figure out why that might be. And I came back and I closed my litigation practice after 11 years. And I founded Ettinger Law Firm in April of 1991 to keep people just like you out of that probate court. Because when you go to the probate court, who's in charge? The judge, right? Now, does the judge ever make a mistake? Of course, every case I lost, the judge made a mistake. And when the judge says jump, your answer has to be what? How high? No, how high, Your Honor. So who wants to be there? I didn't even want to be there because I was the lawyer, but I wasn't in charge. The judge was in charge. I didn't have control. And if I didn't have control, my client had even less control. And everybody wants control. They don't want to give it away. So I thought anything that takes control away from the courts and government, gives it back to the clients, is a good thing. Not only that, but you pay highly for this privilege. It's costly. It's time consuming. It can take years easily. We have many probates that took years. And it's stressful because you don't know how much it's going to cost. You don't know how long it's going to take. You don't know when you're going to be able to get your hands on the other assets. Not only that, but the will is a public record. Anybody can go down and look up how much you had, who you left it to, all their addresses are there. I mean, not something you would really want in the public domain these days. Maybe, 100 years ago, but not today. But what about the reality of the situation? What about you have a house? Can the executor sell the house? No. In fact, the executor can't even list the house for sale because until he's appointed executor, he can't sign a listing agreement. You may need money to pay bills, can't get it. You might need a stock portfolio to be managed. Things are going haywire. You can't sell stock. You can't change the assets. So it has a very negative effect. And this is why people have moved away from wills, especially people 60 plus, have moved away from wills in favor of trusts, because trusts say who takes over if you become disabled, you have a good plan for disability, avoids this court proceeding on death. And nobody wants to go to court if they don't have to. So trusts become very popular. So the trust avoids probate court proceedings entirely for trust assets. Saves time. These are settled in weeks now instead of years. It avoids considerable legal fees. It's a fraction of what it costs to probate a will to settle a trust because you don't have all those court expenses and time, and you don't have any court filing fees. But there's something important in here I want you to notice, that it avoids probate proceedings entirely for trust assets. If it's not in the trust, well, you want to make sure it has a beneficiary. That'll avoid probate. If it's joint, it'll go to the joint owner. But if it's not joint or no beneficiary, it's going to have a probate. Even if you're a couple, one spouse will die first and then there won't be anybody else on the assets. So at Ettinger Law Firm, we have a tremendous amount of experience with making sure the assets get into the trust. And I'll tell you what the number one thing is. We have learned you cannot leave it to the clients to fund the trust. I don't care what the client says. I don't know if they, 10 fingers up to God, swear on a stack of Bibles are going to do it. Half the time it doesn't get done. I'm not saying maliciously. Other things interfere, they forget, they got too many things on their plate. Who knows? We make sure it gets done. And that's because of our experience. We know how to get the assets in the trust. We do most of it for you. And then we supervise what you have to do. The bank, you have to go in person. But we give you the paperwork. Here, just hand this to the bank and they'll have everything they need. So it's not a matter just of setting up a trust. It's making sure the trust gets funded. And we care about that. But the main thing is, now you're in charge of the estate. The court is not in charge. That's a place I'd like you to be. Upon death, the backup trustee can act immediately without the need for court of appointment. Well, people will tell you, anybody has experience with this, it's night and day. The backup trustee, all they need to do is wait for the death certificate, which comes out in a couple of weeks. And then we prepare an affidavit saying so-and-so died. Here's a copy of death certificate under the terms of the trust, so-and-so is the backup trustee. And here's their acceptance of the trusteeship. Please change the names on everything to the name of the backup trustee so they can distribute the assets in accordance with the terms of the trust. We do all that for you. That's estate administration. Nice thing about trusts, they are private. Nobody knows how much you had, who you left it to, who you left out. Only people named in the trust get to see it. Quite valuable. And trusts are very hard to contest. So if you're leaving somebody out, or you're leaving them less than they think they're entitled to, they're going to have a very hard time challenging the trust. And the reason for that is there are a number of reasons, but a couple of them are in challenging a will. Remember, the will is already in court because you had to file it for the probate. If somebody objects to a will, they just have to file one page in the court saying, I don't agree. And now the whole proceeding stops because there's a will contest and it has to be decided by the judge. So it turns out that will contests are often settled in favor of the illegitimate heir because legitimate heirs can't get their share unless they fight the case, which could take a couple of years, and during which time they can't get their money, or they settle. Well, they want their share now. They don't want to wait a couple of years and pay high lawyer fees for a contested matter. So they end up settling with the disgruntled heir. The heir was that was left out or left less than they think they were entitled to. With a trust, it doesn't work that way. Because it's not in court, the trustee is free to distribute the assets. The trustee distributes the assets. If somebody wants to challenge, they have to go and sue all the heirs. That's much more difficult. Lawyers don't want to take a case like that. And also, the case law is in favor of trust. Judges traditionally have felt that if somebody took the time and effort to meet with an estate planning lawyer and set up a trust, they were probably pretty sophisticated. They probably knew what they were doing. And so trusts are accorded a higher level of respect by the courts than wills because anybody can do a will. So there you go. And trusts are done by specialists who take more time and effort and attention, or are more highly trained. So again, trusts are very, very hard to challenge. A lot of lawyers won't even bother for the procedural reason. So if I'm a lawyer and somebody says I want to challenge the will, I know if I challenge the will, everything stops and everybody has to come to me. I have the procedural advantage because nobody gets their share until that will contest is decided. So they're coming to me. With a trust, I don't have the procedural advantage. It's not in court. The assets have been distributed. I have to go to court and start a proceeding and run after the heirs. It's like, trying to get the horses back after the barn door has been left open. So lawyers don't like to challenge trusts for all of these reasons. Now we want to talk about something called the multiple probate problem. Let's say you have a house here in New York and one of these pastel colored condos in Florida. You have to probate in every state we own property. Not only that, but you can't start the Florida probate until you finish New York because you got to get your papers from New York to file in Florida and then start a Florida proceeding. So it takes twice as long. Fortunately for us, you can deed your property from any state into our New York trust and you avoid all the probates. So word to the wise, if you own property out of state, you probably want to use a trust. So before we move on to reason number 3, reason number 2, reason number 1, avoid guardianship. Reason number 2, avoid probate. Keep control in your family and be able to settle the estate immediately on death without the expense and delay of a court proceeding. Reason number 3, remember the 4 advantages of using trusts. Trusts protect the inheritance you leave if the children get divorced or sued from their lawsuits and creditors, and they keep your assets in the bloodline for your grandchildren. Wills don't do this. So I think you'll find this interesting. This has been around. I invented this trust in 2008, so it's certainly not new. Okay, if you have any questions, just type them in. But so we've had this trust, going on 20 years, very effective. And let's see why it's so popular. We've done tens of thousands of these trusts. Instead of leaving it to your son or daughter, you leave it to a trust for them. Okay? Well, the difference between leaving it in a trust is quite different. So you leave it to your son or daughter. Okay? So you passed, your daughter has got the inheritance, whatever, a few $100,000. If she dies before her husband, it goes to her husband. Can he get remarried and share your inheritance with a complete stranger? Of course. Probably most people listening know somebody this has happened to. I certainly know many. So we might want to leave it to a trust called an inheritance protection trust. So now we'll call our daughter Sally. We leave it to the Sally Trust. Sally's in charge of the trust. She can spend whatever she wants. She can buy, sell, trade, spend. She can spend the whole thing. You're not ruling from the grave. So what's the advantage of the Sally Trust? It protects her if she gets divorced. Now think about this. Think about the social side of leaving an inheritance. Look at the difference between Sally saying to her husband, well, I got this check for $1 million from my mother's will, and I'm going to put this in my personal account. Thank you very much. That might not go over big, right? But how about Sally telling her husband, oh, mom died and she left a trust for me? You can see the difference, obviously. She's not the bad guy. So you protect her. So now it's in a trust, Sally's in charge, but it's protected if she gets divorced. What's the divorce rate? Maybe half? That's pretty good protection. Protects her from getting sued or creditors. Who gets sued today in this country? Everybody, for every reason. But the main thing is protection from it going to in-laws and their families. So Sally dies, it doesn't go to her husband, it goes to her children. If she doesn't have children, it goes to her brothers and sisters. If she doesn't have brothers and sisters, you can say where you want it to go because you wrote the trust, but it's going to go where you say. And you're going to want it to go to her children first, but if she doesn't have children, you'll probably want it to go to her brothers and sisters. Maybe there's an estranged one, you could leave them out, the type of thing we talk about in the consultations. But the main thing is not going to in-laws and their families. So it keeps in the bloodline. But it also affords protection against the beneficiaries themselves. People have children who have all kinds of issues, of course. They could be learning disabled, health issues, substance abuse issues. They could be a soft touch. They could just be very poor at handling the money. They could have a spouse that controls them, and you don't want that spouse in charge of your money. So you might put somebody else in charge, either as a trustee or as a co-trustee with them. Let's go into this a little deeper. Here's our family, 3 generations. So there's Bobby and Mary, the grandkids, grandma, grandpa. Okay. So the inheritance is going to go, let's say it's Mary. Okay. So we're going to say this is Mary is the daughter of this couple. That's the son-in-law, her husband. And these are 2 grandkids. So if Mary dies, whatever the grandparents left her is going to go to these 2 youngsters, 3 of them. There's one. There's 3 there. And it's going to be held in trust by another relative that you choose until they're older, usually 30 or 35. The relative using the money for their health, education, maintenance, and support. Whatever they don't spend on them, they turn over at age 35. What if your son doesn't have children? It goes back to their brothers and sisters, then it goes to your grandchildren, their nieces and nephews, etc., bloodline. Now, a lot of people are very fond of their son-in-law or daughter-in-law. So you have an option here. You could say, if when Mary dies, she's still married to Bill, and they're cohabitating. People could be married but living separate and apart. So she dies first, they're living together as husband and wife. You could say, well, give half to my grandkids at that time, keep the other half in trust for Bill, give him an income for life, and then when he dies, the second half goes to the grandchildren. So if he gets remarried, wife number 2 doesn't get any of your assets, he gets the income only, the trust principal is protected, and passes to your grandchildren on a second installment. Some people start saying, okay, Mary doesn't want everything to go to my grandchildren. You'll see we review it every 3 years. They say maybe when they've been married a longer time, maybe we'll do something for Bill. But for now, we want it all to go to our grandchildren. And again, this is one of the benefits of Ettinger law firm plans. We review them for free every 3 years. So you get to change your mind later on. You want the plan to work when you need it, not when you wrote it, hopefully decades earlier. But the main thing here is your careful planning will continue for decades after you're gone, and it'll make all the difference to your family. So reason number 3, trust preferred over wills, because trust can protect the inheritance you leave from your children's divorces, losses, and creditors passed by blood instead of by marriage. And then the 4th reason why trust is preferred over wills, trusts protect your home and life savings from long-term care costs. Wills don't. I mean, if you only have a will, by the time you got to the will, there might be nothing left because nothing was protected. So here, We're talking about the famous Medicaid Asset Protection Trust, the MAPT. So here you place your home, certain other assets in the MAPT, and it helps you qualify for Medicaid for home care or for facility, nursing home care. These trusts have three roadblocks the Medicaid simply can't break through. First, it's an irrevocable trust. Now, the amount of misinformation about irrevocable trust is tremendous. You cannot research this yourself on the internet because there's 100 different kinds. And not only there are 100 different kinds, but there's different rules in different states. You need to know about one trust in one state, and this is the MAPT. So here's a rule in New York that doesn't apply in most states. In New York, an irrevocable trust can still be revoked on consent of all the named parties. So mom and dad set it up. It's an irrevocable trust. They can't revoke themselves. Hence, it's an irrevocable trust. But New York has another rule on the books that says that if every person named in an irrevocable trust agrees that they no longer want the trust, you may revoke it on consent of all the named parties. It's even better in New York. The way our trust is designed, and I think it's the best in the industry, from my experience, is we can change who's in charge. We can change who we leave it to, which means if I want to undo the trust and one of my kids won't sign, I can take them out as trustee. I can take them out as a beneficiary first. They're no longer a party to the trust, and then I can undo it, which means what? I have complete control over that trust. I can do it any way I want, even if somebody won't sign, because I can take them out first. It's a wonderful thing because I preach control. And I sleep well at night because every irrevocable trust I set up, I know I can undo. And that's a good feeling. Nobody ever comes to me and is painted. I get a lot of people come to me with trust done by other firms. I'm sorry to say, I wish it wasn't, that they can't fix, they can't undo because the lawyer didn't know that you could set up a trust where you can change the trustee. The lawyer didn't know you could change who you leave it to. And it took me many, many years. I could never figure out why would a lawyer not set up an irrevocable trust that allows them to undo it. And I finally figured it out. It's because that a lot of lawyers who set up these trusts have never filed for Medicaid. They set up the trust, but they don't know Medicaid. They never filed a Medicaid application. Now, I'm glad to say at Ettinger Law Firm, we filed well over 5,000 Medicaid cases. So those lawyers are afraid of running afoul of the Medicaid rules. They don't know the Medicaid rules, so they're extra careful. We know the Medicaid rules, so we're extra liberal because we know Medicaid doesn't care if you can change the trustee. Medicaid doesn't care if you can change who you leave it to. So I can make these trusts very flexible and I can always undo it. In other words, if it's an Ettinger trust, you can undo it. You have complete control over the trust. So when you read or hear from friends, relatives, financial advisors, accountants that you can undo it, they're just wrong. And when people come to me and say, my accountant said, or my financial advisor said, I say, well, you didn't get a professional opinion. You got a personal opinion coming out of a professional's mouth. It's not their field. In any event, I'll move on from that and go further into the trust. You have to name somebody else as the trustee. People usually pick one or more of the adult children. People don't have children. They usually don't bother protecting their assets in long-term care because they say, look, if I need it for myself, I'm going to use it. And whoever's getting it after I'm gone will get what's left. But I'm going to take care of myself first. These are called income-only trusts because they only pay you the income. You put in a CD, you only get the interest. You put in stocks, you get the dividends. You put in your house, it doesn't earn income. You get the equivalent, the exclusive right to live there, use and enjoy this property during your lifetime. Keep all your exemptions, star, senior star, veterans, you don't lose exemptions. The trust can sell the house, buy a condo, no problem with that. It doesn't start the 5 years over again. So now we're going to take a deeper dive. It doesn't affect your lifestyle because you get all your income. It doesn't affect your income. You get your Social Security, your IRA, your pensions, your interest, your dividends. So your income is the same. It makes sense for assets you're not going to spend like your home. Well, you're sure not going to spend your house. So protect that. What about investments that you're just taking the income from, or not even taking the income, you're just reinvesting it? Put in the trust, because if you have a nest egg that you're not spending, then you're really safekeeping it for the long-term care industry. Better to safekeep it for your family in the trust than to safekeep it for the long-term care industry. So you put the house into the trust. It's life rights. You have the exclusive right to live there, use and enjoy your home. As I said, you keep all your exemptions. You have complete control of the trust, reserve the right to change the trustees at any time. And in the end, if you need care, Medicaid only gets the income. Your nest egg is protected for your children. A few more rules. The trust can sell the house, buy the condo, doesn't start at 5 years over again. You can buy and sell and trade stock. You like to run your stock portfolio? You name your son or daughter as the trustee, and they file with your financial advisor something called a third-party authorization. I authorize mom or dad to trade on this account, and you run it the same as before. We know there's a 5-year look back for facility care. Everybody knows that. And there's possibly a new 2.5-year look back for home care. Now, this has been brought up every year except 25, but for the last few years they keep bringing it up and it keeps failing to pass. So it's starting to look less and less like a possibility in New York, but you know, who knows what the future will bring. Right now, there's no look back for home care. You can move the assets this month, qualify for home care next month. So you put money in the trust. Later on, oh, you need $25,000, $50,000 for something. How do you get it out? Well, we have a gifting power. You cannot take out principal because if you could get it, Medicaid could get it. But you can give to any amount tax-free to your son or daughter. Can't give it back to you, but they can spend it on you. So let's say you need $50,000 to take your whole family and your lawyer to Disney World. Well, you can't take out the 50, but you can make a gift to your son or daughter 50,000, and while they can't give it back to you, they can spend it on you. They could pay for the trip to Disney or whatever else is you want them to pay for it. If you need to do repairs or improvements to the house, because the house is in the trust, that's not taken out. You can use any of the trust money to repair or improve your home. That's not a problem. So when I apply for Medicaid, I have to show them what you took out of your name and put into the trust. I do not have to show them what the trust gave to somebody else. So you gift it to your son or daughter. They can't give it back to you because the Medicaid is going to see it in your bank account, but they can spend it on you. It's their money. They can do what they want. Very important. IRAs, 401ks, 403bs, 457. Those deferred plans are exempt from Medicaid. They can't get your retirement accounts, except for the RMDs, required minimum distributions. That's income. You have to take it out. If you're receiving government benefits, they get the income. Nothing we can do about that. But it's 4% a year. That's not the nest egg. They can't go into the IRA itself. It always pays to get started. Because let's say you set up the trust 4 years later, you have to go into nursing home. You only have to pay for the 1 year that's left. It always pays to get started. You don't have to make the whole time to get the benefit. And then after 5 years, you're home free. So our conclusion is very much like our introduction. Estate planning with trust creates order out of chaos, and disability without a plan, death with a will creates chaos. So here's how we create order out of chaos. We don't have a guardianship. We have control in the family, and the family has all those asset protection options. We don't have a court proceeding on death. The family's in control, saves significant time and money in settling the estate, and keeps your affairs private. Protects the inheritance you leave if the children get divorced or sued, and passes it by blood to your grandchildren instead of in-laws and their families, and protects your home and life savings from long-term care costs, make you eligible for Medicaid for home care and nursing home care if and when you need that. That looks like a plan. But overall, you also have a firm with tremendous amount of experience in thousands of cases. We've set up, well over 35,000 trusts, filed well over 5,000 Medicaid applications. But the main thing is we're a calming, knowledgeable presence. We're anti-stress, anti-anxiety. I tell clients, call me. Don't stress. It's no bother. Call me anytime. I don't care how many times you call. I want you to be calm. I want you to be comfortable. I want you to be safe. I want you to be secure. You have Ettinger Law Firm behind you. That means something. We're not going to let anybody push you around. We're not going to let anybody take advantage of you. We're going to eliminate your stress. That's what we're here for. And we have a unique planning process. It's already begun with this seminar. This is quite a good warm-up. We offer a no-cost initial consultation, very low-key, where we're going to review what you have now: will, trust, power of attorney. And if they need work or they're defective in some way, we'll explain it to you. We don't just say, well, this is bad or this isn't going to work. We explain it to you. Here's the issue. Here's what you need to do. This is why you need to do it. Here's what's going to happen. Here's why this won't work, etc. We're going to give you a copy of my book. This is 2025 edition. I'll update it next year. This is my third book, Guide to Protecting Your Future. And we'll tell you which chapters apply to you. I have chapters on every subject that you need to know. It's well over 300 pages, but it's written in plain English, big print, and I think you'll find it clients really get a lot out of this book because they can understand it, and the information is correct. This is my third book since 2010. And every lawyer reads it, and it's all over the internet. It's on Amazon. Nobody's found a mistake in that book yet. So there you go. It's good to have a place where you can get the right information. It's so hard today to get the right information. So now you'll be told which chapters apply to you. Why do I want you to read those chapters? Because I have an expression. I say, if you don't understand the plan, you don't have a plan. So we want you to understand it. That's why we're going to have 2 meetings before you make any commitment. We're going to tell you right in the first meeting, this is what you need. This is how much it'll cost. Because everyone wants to know. It's no secret. A couple of people in the questions ask, how much does it cost? Look, there's no mystery. If you're going to go with a quality firm that knows what they're doing, it's going to be $6,500 and up these days. Additional fees are for filing the deed. You have to pay deed filing fees. What does and up mean? Well, do you want inheritance trust for your children? Those are separate. How many children do you have? 3? You need 3 trusts. You have 4. You need 4 trusts. Do 2 trusts. And of course, if you have a taxable estate, which today is over 7 million, you'll need more advanced planning. Costs a little more to save the estate tax, which is if you're over 7 million or so, it starts at about 600,000. We can wipe out that tax with some planning. So of course you'll pay a little more, but it's going to be well worth your while. So you'll know right away, this is what it's going to cost you. So now we set up a second no-cost consultation, maybe 2 to 3 weeks later. So you're still fresh. You read the book. The chapters we assigned to you might be an hour and change in reading. We don't overdo it. And now you come in for your second meeting. We answer any questions you have. Now you see we're building your confidence, okay? You had the seminar, you had the first meeting, you read the book, you had your questions answered. All the time your confidence is building and building so that come time to make a decision, you know what you're doing and you feel certain that you're doing the right thing. So we draft the estate plan together with you. What does that mean? Well, who do you want to make medical decisions? Who's your first choice? Who's your second choice? Who do you want to handle your legal and financial affairs? First choice, second choice, 1 person or 2 people. If it's 2 people, generally they can act independently. They just report to each other. How do you want the plan distributed? All at once or over time? Do some people need protection? Let's look at the options for protection. You want to spill it out over a period of years, that sort of thing. At the end of the second meeting, we give you a detailed written proposal. Now it's the same fees we mentioned first, and now it's in writing. So now you have everything, your questions are answered, the plan is drafted, you got the proposal. What would you like to do? A lot of people fortunately say, sounds good, let's go ahead. We say, fine. At Ettinger Law Firm, I believe this is unique in the country. You don't sign anything. We don't have a retainer agreement. We have a fee proposal. and we list everything we're going to do. But our fee proposal, we sign it, you don't sign it. And our fee proposal says we're going to do all this, and you'll come in a third time. We'll go over all the documents. After everything is signed and you're satisfied, you pay at the end. But unless you write us a check at the end, you owe nothing to the firm. You're free to walk away. Why? Because we want to keep you in control. So imagine this. I've been giving this talk for 35 years or so. And about 10 plus years ago, I realized something. And it was astounding to me, but I'll share it with you. I was trained like every other lawyer. And the way I was trained was when a client wants to do an estate plan, you have them sign an agreement. They give you a check for half the fee to get started and the other half at the end. And I took it as gospel. I never questioned it. But all of a sudden, one day, I realized that the way I was trained was not necessarily the best way to do it. And here's what I realized. When you hand the lawyer that check for the retainer, what do you have? You have nothing. Actually, what you have is a loss of control because you now handed the lawyer a check for a few $1,000s and you have nothing. You just have a promise that the lawyer is going to perform, and you have to hope the lawyer performs in a timely fashion to your complete satisfaction. So how could I give a talk for an hour about keeping control, and then the first thing I do when you come to my office is I take control away? It didn't make sense. So I decided that it makes a lot more sense for us to give you back the control, not take a retainer, put you in charge, because clearly, if you're in charge till the end, until you're satisfied, that's the best place for you to be. And if it's the best place for you to be, and we're here to serve you, then it must be the best place for us to be. So we pioneered this. I'm pretty sure, because I've never seen it anywhere else. I can't even get any of the lawyers to understand it hardly. I'm pretty sure we're the only firm that does it, but people like it, and we like it. We only have happy clients at Ettinger Law Firm. It's a nice place to be. So you come into that final meeting, we review everything, go over all the legal language. You're satisfied, you sign, and then you pay at the end. Credit cards are accepted, but most people pay by check because there's a 3% with a credit card. But you can pay it all at once. You can pay it in 3 monthly installments, whatever you like. It makes no difference to us. Just some people like to pay it because it works better for them to pay it in 3 installments. Now, what's the standard in New York? After you sign your plan, thank you very much, goodbye. That's the standard. We don't say goodbye. We say hello. Welcome to the firm. We have a trademark process. We keep you up to date with law changes and other matters through our weekly Ettinger Elder alert. It comes by email, so we call it the alert. I publish it. But the key is this. Every 3 years, we call you in for a free review of your plan to see if there's any changes in your health, your assets, your family, births, deaths, marriage, divorce, etc. We want that plan to work when you need it. At Ettinger Law Firm, we don't charge for phone calls, emails, or questions. We want you to communicate with us. We want the door to be open. Okay, we're very responsive to your needs in that way. But the key is by using this program, your plan is never more than 3 years old. It's going to work when you need it. Not when you signed it, I hope, quite a few decades earlier. It's been very effective. We have very, very many happy clients, and we're happy to have them. And so the other thing about this is we're building a relationship. We see you every 3 years. You call, you get your questions answered, email. We send you a law letter once a week. You're going to be part of we're like family. We're your trusted advisor, and it's a place we like to be, and it's a responsibility that we're very proud and happy to discharge. It's very satisfying work that we do. I did a video and I said, if you do something you love, you'll never work. If you have a job you love, you'll never work another day in your life. And I love it. Suzanne loves it. Our employees and paralegals and other lawyers, we all love this work because all we're doing is helping people. And what could be more satisfying than that? And they really appreciate what we do for them. So to schedule the consultation, it could be with myself if it's one of my offices. I work in White Plains once a week. I go to Staten Island every couple of weeks, but I'm mostly in Rockville Center, or I'm in Lake Success. Suzanne is in Islandia, Melville, Huntington. I'm in Huntington. We live in Huntington, but we have all the lawyers. I've trained all the lawyers. We all do everything according to systems and processes, always the same. Um, so we have excellent lawyers all over the state. Bonnie Cram in Middletown and Albany. Um, uh, so many. Lindsay Thomas in Middletown. Michelle Berman in White Plains and New City. Very experienced people, and they always have me to consult with on uh, any matter that's perhaps more complex. But these consultations are available in the office by Zoom or by phone, whatever works for you. Just call the 800 number or visit us at ettingerplan.com. Okay, so now you're going to get a copy of this. This whole presentation will be sent to you in an email tomorrow or later today, but within the next 24 hours, you get a copy of this. You can watch it again. I'm going to stop the share now, and we're going to go into the big screen and see about any questions we have to answer. Okay, so we have 16 questions. If a question comes up, just add to the list. Okay, so John and Marlene say, we set up a trust in 2015, an irrevocable trust from our attorney at that time. There's no question there, but if you want me to look at it, John and Marlene, there's no problem. Call and make an appointment. I'll review it. And if it's good, I'll be happy to tell you it's good. And it doesn't waste my time. I don't consider anything a waste of my time, actually. I'm happy to look at it and troubleshoot it for you. If there's an issue, I'll explain it to you. I'd like to look at that power of attorney, health proxy. If everything's in order, I'll still be quite happy you came in to see me. In fact, I tell people all the time, people come in to see me, and I can't tell how many people come in to see me and say, I want a trust. And I say, well, let's see if you need one. And it turns out they don't need it, or there's something else to do, or they're not ready, or it's not cost effective. And they say, well, I'm sorry for wasting your time. And I said, no, you didn't waste my time. I'm really happy you came to see me because, or any of my lawyers, we don't do anything that doesn't need to be done. We pride ourselves on that. We don't do a trust because somebody wants it. We do a trust because it makes sense for them to do it and it's cost effective. The value of getting it exceeds the cost. Otherwise, it doesn't make sense to do it. Teresa asks, with a trust or will, is it state specific or is valid in any state where you reside? Well, you want to do a trust in the state where you live. If it's valid in the state where you live when you set it up, you can take it anywhere. It's portable. Okay. Lisa, why did your attorney in the Rhinebeck office tells us that we could not get a trust because we didn't have enough money? Okay, well, hard for me to speak for somebody else. My grandparents and parents had a trust, so I was very confused. So we have a will and we want a trust. We feel like we're given incorrect information. Lisa, when we generally say that you don't have a trust, we're saying that it doesn't, it's not cost effective. The cost of it, you're not going to get the value from a trust. But I will say this, if you like, you can make a Zoom with me. I'll be happy to spend the time with you. I'll look at it and I'll explain to you if you don't need a trust, why you don't need a trust. Usually we'll explain you could do something that's less expensive in a trust and get the same benefit. So call the office, please. You have the 800 number. So you'd like to have a Zoom with me. I'll go over it with you, and hopefully we can reach a consensus. Obviously we wouldn't turn away business that's good for the firm and good for you. We only turn it away if it's not good for you. So let's explore that further, okay? It's possible there's a misunderstanding, so I'm happy to look into it further. Les, do the heirs of the trust see what the other beneficiaries get? No. You can redact the trust. You can, if somebody gets a percentage, they're going to get to see all the assets, but they don't necessarily have to see who else gets the other percentages. It's called a redaction. You send them a copy of the trust with only what they get. Anonymous, how much money? How do you move money in bank accounts with beneficiary designations into the Inheritance Protection Trust? Well, you change the beneficiary to the Inheritance Protection Trust, and you can do that right at the bank. Joanne says, upon death, you said the trustee distributes the assets. To whom and how is this designated? You know, the trust is just like the will. It says, when I'm gone, give this amounts to these people, give these percentages to those people, and the trustee follows the instructions as you've left them. We help them collect the assets, pay the expenses, and distribute according to the terms of the trust. So it's called estate administration, and lawyers help with that. Melissa says, mother's in hospital now. I'm sorry to hear that, Melissa. I'm power of attorney, but my uncle said I need a TOD and a will. A TOD is a transfer in death, and a will. Is that really important right now? My mother only has a trust with one life insurance policy in it. Her home and assets are not part of it. Well, if she has a trust with a life insurance policy in it, that's called an ILIT, irrevocable life insurance trust. But if she's in the hospital and you have power of attorney, the power of attorney may or may not allow you to set up a trust. They'll have to look at it. But we want to see what we can do about avoiding probate. So we might put a beneficiary on the house deed. We might create a trust and put it in it, whatever is the most cost effective. So make an appointment, come in and see me, and we'll talk about it. Okay. So a little more about your mom. I'm not going to disclose it here, Melissa, but obviously she's not doing well. So you should come and see us as soon as possible. We'll get you in right away. Not a problem. Anonymous, if creditors know there's money in Inheritance Protection Trust, can they still go over that money in the future? No, because it was set up by a third party with third-party money. It's not available to creditors. Anonymous, how do you transfer money into Inheritance Protection Trust? Well, if the parents have a trust, the trust will say on death it pays out to the Inheritance Protection Trust. But you can name an Inheritance Protection Trust as beneficiary on an IRA, on a bank account, on an investment account as well. Anonymous, how do you transfer money? Okay, same thing. On the beneficiary designation, instead of a person, you name the trust. We'll help you fill that out, not a problem. Doreen asks, after a death, how do you know if a trust has been set up? Well, you know, when somebody dies, if you don't know, you have to go looking through their papers and see what their plan is. Hopefully you can get into the house or apartment. Victor, you know, usually people will, people set something up while they're living and tell somebody what happens where their papers are when they die. Victor, if I have a two-family home, can I put into the Medicaid trust and still collect rent? Yes, absolutely, no issue there. Do it all the time. Glenn asks, if an irrevocable trust sells the primary home, what is the basis and what tax return is filed? A trust return or a personal 1040? Okay, so the irrevocable trust that we're talking about, the Medicaid Asset Protection Trust, set up by Ettinger Law Firm, is tax neutral. Tax neutral means it does not affect you tax-wise. So whatever your tax situation was without the trust, it's the same with the trust. So if the house is in the trust files what's called an informational return and says all the income, all the capital gains, everything is flowing through the trust beneficiary, which is you, to your individual return. You'll pay the tax on the individual return. So it's a pass-through. The trust passes through the individual return. I have a letter for the tax preparer. So if you sell the house, if you're a couple, you can exclude $500,000 of gain. Single person, $250,000 of gain. If you sell it after death, the heirs pay no capital gains taxes. Death wipes out the capital gains taxes. All the tax benefits you had without the trust, you have with the trust. Can you talk about cliff tax in New York? Well, in New York, we have some noise outside. I don't know what that is, a loudspeaker? Okay, in any event, New York taxes the states on the amount over 7.16 billion. It's indexed to inflation. Like a boombox outside. So yeah, next year it'll be 7.3 in January, 7.3 million. If you're over 7.3 million, the cliff means that if you go over the cliff, they tax the whole estate. So if you're over 7.3, give or take a few dollars, they tax the whole estate. Tax starts at about 600,000. You can avoid the cliff tax if you have a spouse. You can set up two trusts, double the exemption. We can make gifts, get you under all kinds of ways to avoid the cliff, but you have to come in and talk to us. Victor, what happens if 5 to 10 years down the road we relocate from New York to another state? Do we need to update it for the new state? Would you take care of that? Well, what I'll do is I'll refer you to an elder law attorney in that state. The trust will still be good. You may want a new power of attorney for that state, health proxy. Yes, we do help with that. Anonymous, do you hold copies of the trust? We give you the original. We give digital copies of everything. We can reproduce it. Please discuss the role of the executor. Well, the executor is the person in the will who has to file the will in court and get appointed and follow the terms of the will. Less. If a trust is valued over the 7.3, but most assets go to charity, will taxes be reduced? Yes. Whatever leads to charity comes off the top. So if the amounts to charity bring you under the 7.3 million, there will be no tax. It's a complete 100% deduction. Okay, I have a few questions here. Were sent in advance. Most of them I already answered. So the ones I haven't answered, I made a note of. Okay. Marie says, my primary residence is Florida, but I live in New York 6 months of the year. Does this state where your primary residence matter when establishing the trust? Well, I usually ask a person, at the end of the day, Marie, let's say you become disabled, go to a nursing home. Would it be in New York or in Florida? If it's New York, do a New York trust. If it's Florida, do a Florida trust, because you're going to want all of your end of life, your Medicaid application, everything there. Michael asks about pet trusts. Well, if you go on my website, I wrote an article about pet trusts. But basically, you name somebody who's willing to do it. You leave a certain amount in trust for the pets, and whatever's left goes to where you want it to. If there's anything left after the pet dies. Not a problem. Now, Joan asks, Joan is a widow with 3 adult children. Is there any particular trust planning information I should know? Well, what you should know, Joan, is if you don't have a spouse, you're much more exposed to the cost of care because you have a spouse. They can protect the house. They can protect a couple $100,000, maybe more with spousal refusal. But you have none of that if you don't have a spouse. So you really need to focus on asset protection because you have no spousal exemptions. Lori, does a trust provide a protection from a lawsuit? Well, yes, as long as the claim hasn't been made yet. You can't, after a claim has been made, you can't set up a trust and say, hey, my assets are protected because that's considered a fraud on your creditors. But if no claim has been made, yes, and you set up the trust, put your assets in, you have complete protection from lawsuits and creditors. Somebody asked about special needs trusts, and Lucia, and go on my website, look under practice areas, and read my articles on special needs trusts, and come and see me. I'll talk to you in person about it. I have a chapter in my book on it. We can educate you there. Here's Glenn again. We have property in 2 states. Is it necessary to form a trust in both states? No. We can deed the property from any state into your New York trust. And does putting a property in trust require any changes with the mortgage company? No. You don't even have to advise the mortgage company. Barbara. Barbara is 79. She doesn't have family and friends to be the executor of the trust. This happens all the time. Doesn't have friends or family to be my health proxy and power of attorney. Can you suggest where I can find people for these roles? The lawyers at Ettinger Law Firm will do that if you don't have somebody else, because a lot of people are in that position. And it's not even that they don't have necessarily friends or family, they have them, but they either don't want to or don't feel they're capable of handling their affairs if they become disabled. So, or they don't want to impose on them, all kinds of reasons. So we help people that way. John and Marlene again. Yeah, I said, I'll look at your trust. If you want to bring it in, I'll tell you if it's okay. I have no problem with that. Are there any additional charges for out-of-state property? This is Soknan. No, you only have to pay the filing fee for the out-of-state property. Carol says, I understand there are variables, but the cost, well, we talked about the cost, 6,500 and up. Is there a way to distribute funds from the trust on passing in annual increments? Absolutely. If you want to pay it annually, you would specify that in the trust, and the trustee will follow your instructions. And then Jim asks, yeah, Jim, if you just put the house in your irrevocable trust, the trust can sell the house by another place. Now, if the spouse that has a high pension needs long-term care, is there a mechanism to protect some of the assets and pension for the other spouse who has lower income? Well, the spouse at home is allowed to keep about 4,200 a month. So if your income is less than 4,200 a month, you're allowed to keep from your spouse who needs the nursing home. You're allowed to keep enough of their income to bring you up to the 4,200 a month. The house is going to be protected. A couple $100,000 is exempt. IRA, 401k, 403b is exempt. So there are a lot of benefits or a lot of ways you can protect assets. So I think we have done it. I want to thank you for coming. 45 of you hung in till the end, so thank you, and wish you all a very good evening and happy holiday season. Hope to see you all in the office very soon. Thank you for coming and have a good night.